That's me.
Testing 1, 2, 3, 4, 5, 6, 7, 8, 9. Can y'all hear it?
Can anybody hear me right now?
Loud and clear. Hear you very well.
We can hear you as well.
The directions for muting their phone is on a sticky note on the podium.
Yeah, well, it's covered up a little bit here. *6 to mute and #6 to unmute. Is everybody ready? This afternoon, we're issuing an Attorney General's opinion concerning two key questions that occur once Lieutenant Governor Kim Reynolds becomes governor of our state. We received earlier this year an opinion request from Senator David Johnson concerning these questions. It's not an question that we reached out for. We thought we had plenty of work to do here in the AG's office without it, but we accepted it and have done the best we could with this opinion request. We've spent a lot of time, a lot of research has been done. We've had discussions and debates within this office and have now reached a conclusion on those two questions. I want to particularly thank Jeff Thompson, who's our Solicitor General, who I think is, if not the best lawyer in the state, one of the best lawyers. And then we had, working with him, two former Iowa Supreme law clerks, Megan Gavin and David Ranch. I want to thank them and acknowledge them for their work. We've issued essentially a split decision on the two questions. Each side will be happy with one result and unhappy with the other one. The two questions are these. First of all, when Lieutenant Governor Kim Reynolds becomes governor of this state, is she flat out Governor Kim Reynolds, or is she acting Governor Kim Reynolds? The second question we address is that once she assumes her duties and her powers and responsibilities, can she then appoint a replacement lieutenant governor? Let me turn to the first one. What is the proper title of the new governor? Yeah, we're getting a little feedback here. Let us just pause for a second. We're getting some feedback and I'm trying to resolve that. Okay, that worked. Thank you. The key word in both issues is really a single word. It's the word devolve. The Iowa Constitution provides that when the governor leaves office, the powers and duties devolve to the lieutenant governor. They don't, it's not a description of the lieutenant governor succeeding the governor or moving up into the governor's role. It's devolving of the powers and duties. When you look at the dictionary and the law dictionaries, devolve essentially is a way of moving down. The powers and duties move down to the lieutenant governor. So then what happens? Does she become governor then or acting governor? Well, in cases like this, we often, and courts often, look to what other states have done in a similar situation. What are the cases in the other courts, and what are the numbers, and how is the reasoning of those decisions? And it surprised me a little bit of how common the devolve concept was. It's the language in the U.S. Supreme Court Constitution, and it's the language in many state constitutions, particularly those that were enacted about the same time as ours. So we reviewed those decisions from other states, and they're about equally divided. In fact, I think one more would say that in this situation, the new governor is an acting governor. And the theory is that those powers devolve down to the lieutenant governor. And the lieutenant governor really is still, in a sense, lieutenant governor, but has the powers and duties of governor because of being lieutenant governor and the governor leaving. Another half hold that even though that is the sort of trajectory of devolve, there are other ways or other reasons why the person should be directed as governor rather than acting governor. And we agree with those that say that this title should be governor, flat out governor. And there are sort of two reasons or two tiebreakers for us given the equality of decisions elsewhere. One, and the main one, is that Article 4, Section 1 provides that the executive power of the state government shall reside in a chief magistrate who shall be styled governor. So we think that there's a pretty clear basis for saying that when that person has the powers and duties of governor, they're called governor. And the second reason that we come to that conclusion is what has happened historically in state governments and federal governments. In Iowa, this has happened 4 times before. The lieutenant governor has become governor. Each time he has been called governor. And of course, there's the national precedent. Again, using the same term, devolve, the vice president upon the departure of a president is always called president. So we think that is a good basis for the decision that she will be called governor. I reiterate what I will mention a couple times this afternoon. These are really close questions, question 1 and question 2. But we think that's a good result. And unless and until our opinion is overturned by a court, we think it's important for Iowans to call her governor, not acting governor. The second question is, can she appoint a replacement lieutenant governor? And here again, we start out by looking at what the other states do. And on this, whether there's a vacancy in the office of lieutenant governor when devolved language is used is not a split decision. It's overwhelmingly on one side. It's overwhelmingly in terms of the other states that the position of lieutenant governor does not become vacant, that there's this devolvement of powers into the lieutenant governor. Lieutenant governor exercises those powers really sort of from that position. And there's no vacancy and no ability to appoint a replacement. There are 7 cases elsewhere that hold that, 2 attorney general's opinions that are similar. There are 2 cases that go the other way, 1 attorney general's opinion that goes that way. And you also look at both the numbers and the reasoning of the opinions as a court would do. There's only 1 court opinion elsewhere in the 50 states that permits lieutenant governor to appoint the new governor to appoint a new lieutenant governor absent a constitutional provision that allows it. And that's the state of New York. And the New York decision was a very divided decision. It was a decision that didn't address the vacancy question for some reason or another. Went off instead, ignoring that and talking about a constitutional provision. And that decision has been roundly criticized in academic worlds and law school worlds. Whereas the other 7 that say there's no vacancy have not been criticized and we think are the better decisions. There are 4 other reasons that we state in our opinion, excuse me, that there should not be a replacement lieutenant governor, and these are these. One is the state's histories. Other states typically do not have a replacement lieutenant governor unless and until there's a constitutional amendment. Then there's, of course, the federal history, that for a long time, a number of presidents left office, vice presidents became presidents, They were called presidents, but they didn't appoint a vice president until the Constitution itself was changed later on in the middle part of last century. So there's a clear historic practice that there is no replacement lieutenant governor or vice president absent a constitutional provision. Then one of the things that our team did, excuse me, was go back and search the debates in the Constitutional Convention of 1857 to try and be informed on these decisions and principles. And one thing that stands out there is called the elective principle. Originally, we had no lieutenant governor in the 1846 Constitution, and then they went about bringing about a new Constitution in 1857. And it was proposed there at one point that we have a lieutenant governor. And then there was an amendment on the floor of the Constitutional Convention to exclude the office of lieutenant governor. And that passed. And then the next day, they rethought it. And they turned the vote around, and they turned it around on this principle, the elective principle. They thought it was really important that the person who succeeded to the office of governor, by far the most important office in our state, be elected by the public rather than an unelected person. So that if the office of lieutenant governor is created as the standby person, and that person is elected, then the people have spoken that this person would at least would assume the duties and would be an elective person, not an appointed person. This elective principle is consistent with what we did today. And then additionally, there's a number of sections in the Constitution that are relatively short, that relate to these issues, and those additional provisions fit together as a group much better when the lieutenant governor's position is considered vacant rather than open for reappointment, including and especially two references to the lieutenant governor acting as governor and the lieutenant governor exercising the office of governor. A clear reference that the person is still lieutenant governor and that there's not a vacancy. I struggled with this second decision, the second issue for a while, and what sort of turned me around, including the brilliant arguments of the three people to the right of me, was focusing on Article 4, Section 19, the succession provision, the gubernatorial succession provision of the Constitution. It's very tight. It's governor, lieutenant governor, president of the Senate, Speaker of the House. There's nothing in there about a successor vice president, appointing a vice president. It's these four positions. And in terms of interpretation, when it's that tight and that clear, you can't add to it by statute for an appointment. You can only go to the constitutional amendment. Which brings me, excuse me, which brings me to sort of the irony of this afternoon for me, and that is that I support the appointment of a lieutenant governor by the new governor as a matter of policy and as a matter of constitutional law. I think for a variety of reasons, including sort of continuity of party holding the office, that it's a good idea. But I think it's only can be done by a constitutional amendment. So I would certainly would support a constitutional amendment that provided for appointment of the lieutenant governor. But for the reasons I mentioned, excuse me, this afternoon, I think it has to be a constitutional amendment. As I mentioned, we've worked hard on this. We've debated it. Initially, I was on the side of the appointment of a new lieutenant governor. The team did all this work and convinced me otherwise. And what really crystallized with me was looking at Section 19 and thinking that this really needs a constitutional amendment, not a statute. So, you know, we've worked hard on this. We've taken some time, admittedly, but we've tried to get it right. And whenever we do an Attorney General's opinion in this office since I've been here, and it's been a while now, I guess, we always try and do it according to the law. What does the law say? Not what politics says, not what policy says. What does the law say? And this is the best reading that we have of the law. It's a split decision, and it's one that we believe is right. Be glad to take questions.
How will you respond to the political argument about this? Because the person widely considered to be her first choice is the person for lieutenant governor, is the person who challenged you in the last election.
Yeah, well, I did not know who the person was until you just mentioned that. I had heard that he was under consideration, but when we did this opinion, we did not know that it would have been him. That would have made it a little more awkward, but it wouldn't have changed the opinion. It wouldn't have changed the cases in other states. It wouldn't have changed the principles that I just described.
What about the timing of this? As you know, their critics are going to say, had this came up in December, you've had all these months, perhaps the legislature could have weighed in to start the constitutional amendment process or whatever to remedy this. Now you're releasing this the day before the governor's hearings. Why now?
Well, we did get the opinion in February, but we spent a lot of time on it. They looked at the Constitutional Convention, the debates. They looked at all the other cases. They argued with me what the results should be, and it took me a while to evolve. And a lot of other things were going on at the same time that we needed to deal with.
Should the new governor draw two salaries then, if she's acting as lieutenant governor and governor?
No, the Constitution provides that she's paid at the rate of governor.
What happens if for some reason she's unable to serve due to an illness or?
Then Article 4, Section 19 provides that the President of the Senate would, the powers and duties would devolve to the President of the Senate.
Just to clarify, so today's announcement is just a coincidence in timing, or did you feel a need to get it out before that hearing tomorrow?
Well, we certainly wanted to wrap it up before the hearing. Originally, we planned that it would be last week, but a few delays entered in.
Spoken with the governor's office?
We have last week.
Can you explain kind of again, what is the actual legal effect of this, and how could the governor's office challenge this if they disagree?
Well, if they were to disagree, and we hope they don't, we think that when we issue an opinion based on the law, the people in state government should follow the opinion and follow us. They could go ahead with an appointment, and that might or might not be challenged in court. But we hope they don't do that.
If they did, this is going to be a two-part hypothetical. If they did,
Oh,
and if
those are always difficult.
If it was challenged in court, would your office represent the governor's office in defending the case? How would that work?
We could not defend the case on behalf of the governor's office because we've issued this opinion that's contrary, that presumably will be cited in any court litigation.
As a follow-up to my question about you've spoken with the governor's office, did they give you an indication on what they intended to do?
Well, they have to speak for themselves. I shouldn't try and be the messenger of the governor or the lieutenant governor.
Could there be any possibility of any kind of special election?
No, there couldn't be a special election because only if there was a constitutional amendment providing for a special election. Constitutional amendment could provide for a special election, but the legislature could not, consistent with our opinion.
Can you speak to the reversal from December? And did your office make a mistake in December?
We took a quick look at the law in December and made a quick decision that we thought that she could make the appointment and that she would be the full-fledged governor, not the acting governor. You know, in part, I think we did because we were familiar with the statute. In part, we may have did it because I agreed with the policy. I thought the policy was right. But, you know, we've taken a much deeper look at the law, what's happened in other states and what happened to the federal government, and have come to this conclusion.
Would this have happened if David Johnson hadn't made a request?
I do not think so. I think it probably would have rested where we were back then. You know, somebody may have challenged in court the appointment, and all these issues would be aired in court. But we have done the formal opinion because Senator David Johnson asked for the opinion.
If she appoints the lieutenant governor, will you challenge that in court?
We will not.
So why wouldn't she just do that then?
Well, you know, we would hope she wouldn't, because we all have the obligation to follow the law, and the best statement of the law currently is an Attorney General's opinion. We think it's you know, thoroughly done, impartially done, and is the best result that we think is available.
So if she goes ahead and does this, she's breaking the law?
I wouldn't say she's a lawbreaker. I think that goes too far. You know, I think she would be asserting her position of what she thinks the law is. What, Jeff?
Questions by telephone.
Okay. People on the phone have questions? Jeff is trying to cue that up right now.
Please mute your phone, *6, unless you have a question. To unmute, hit #6.
I have a question. Who would have, if your office would not take it to court, if Kim Reynolds tried to appoint a new lieutenant governor, who would have standing to challenge that decision in court?
If she appointed the lieutenant governor, and who would have challenging standing? Well, I think
In defiance of your opinion, you said, if I understood you correctly, you said your office would not challenge that action in court. So who would have standing to challenge it?
well, you know, perhaps a voter. Perhaps it might be a stronger interest than that. Standing is a pretty significant question, but one way or another, you know, there would be a person who would have standing that could challenge it.
Jack Whitver, Linda Upmeyer?
They certainly would have standing, but I don't expect them to go to court. Any other questions?
They certainly would have standing, but I don't expect them to.
Yeah, Jeff, you know, you worked an awful lot on this, and a lot of you is in these 23 pages. Anything you want to add?
Just this, I guess. We, you know, in this office, we wear different hats. Often I'm the advocate for the administration in front of the Supreme Court. We defend agencies, we defend actions, we give advice. When we're asked for a formal Attorney General opinion, our role changes. And the statutory duty we have is to try to get the right answer. And that's what we tried to do here. And it wasn't easy. We worked really hard on it. And in the end, as we drilled down and read the debates of the Constitutional Convention for Iowa and heard that they decided to have a lieutenant governor so that the person who could become governor would be elected. In some ways, that's the core principle that we found in here, and that the Constitution, as was written, and when you look at it all together, really effectuates that goal. We think it's the right decision. We think that it vindicates the historical practice, which is 4 times in Iowa, lieutenant governor became governor, did not appoint a new lieutenant governor. 8 times under the same legal framework, the President of the United States died, the Vice President became President, and there was no new Vice President. And so we think that reflects an understanding of how this framework worked. That's true.
During the 4 previous instances, the lieutenant governor was independently elected.
True.
So why the comparison?
Well, and if you look at our opinion, we've looked at all the amendments. We don't think the 1988 amendment changed that. It required that they both be elected still. Yes, elected on a single ticket, but the other provisions of the Constitution remain the same, that both of these are elected offices, that they needed to be elected, and it didn't change the succession line as Tom talked about in Section 19, nor did it change any other provisions that dealt with the situation where a lieutenant governor might be acting as governor temporarily where there's not a permanent disability. And all those things work together to convince us that these are the right answers, because otherwise you make the succession framework not work under some fact scenarios. Thank you.
Any other questions? If not, thanks very much.